nobody's saying this was okay. This
Right.
is a heinous, horrible
Yeah.
act of violence, but we have a statute that covers heinous, horrible acts of violence. It's called murder.
Right.
And you don't have to then stretch this definition of terrorism because you think this person may have had an ideology.
What happened to Charlie Kirk was awful, terrible. It was murder. It
Yeah.
was not domestic terrorism.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing. Hey everybody, Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. It is about 2 in the afternoon on September 16th, 2005, and because it's a Tuesday afternoon in the middle of the day, I'll be sipping my Coca-Cola beverage.
Soda.
You can see over my right shoulder there though. I've got two beautiful bottles of tequila. They're just calling my name. They're like,
Uh,
"Doug, you really should take a sip because you're going to be talking about terrorism and you need to drink." But I'm not going to. But yeah, that's what we're talking about. I've got Mark Allen Bob back with me today. Hi, Mark. How are you?
hey, Doug, I'm doing well.
I hate that we have to talk about terrorism today, but we do. Now
Yeah.
this is not the first time we've talked about it because, we've handled cases where the federal guidelines have this terrorism enhancement. We got to
Mhm.
talk about that some more, but we did, I think it was episode maybe 108, and it was called Reign of Terror. And it was basically about how the DOJ is using this terrorism label to further their own political agenda. And
Mhm.
very broad definition, and it was the first sort of, dare I say, shot across the bow from us to say this is not the way the terrorism label should ever be used.
Right.
And then something very significant, well, two things happened very significant this week. The
Yeah.
first is Charlie Kirk was assassinated, so we're gonna have to talk about that. But then
Yeah.
today, you sent me a fresh ink opinion from the New York. They call it the Supreme Court, right? But it
Yeah.
was
Right.
really just the district court level. That's how they do it in
Yeah.
New York. But anyway, they dismissed the terrorism charges, the state terrorism charges for Luigi Mangione, who's accused of killing the CEO of a health insurance company. And
Yeah.
so their rationale for dismissing the terrorism portions of this indictment are so directly applicable to the federal stuff we're doing at federal sentencing that it
Mhm.
was it was a very big deal, and we wanted to come in and talk about all this and put it all in the right
Right.
context. So,
It's also pertinent to Kirk, or to Kirk's assassin, to Tyler Robinson. It's a
and
pro. Yeah. Yeah.
you because they're gonna probably charge him federally, and
Well, I mean, that's what I don't know how they're going to get jurisdiction to charge him, but that's what all the threats are. Be that, you hear from Kash Patel and Pam Bondi and Trump,
yes,
that they're going to go because the feds, do have the death penalty just like Utah does. But that's so
yeah,
how
and
they,
they've already branded him in the press and everything else as a domestic terrorist, and
correct.
this
Yeah.
is
Yeah.
an act of terrorism. So
Yeah.
yeah, it's going to be very pertinent
Yeah.
to that. Well, I mean, I guess before we dig into the thing, let's talk about Kirk. Everyone's talking about Kirk, and
Yeah.
everyone has their 2 cents to say about what this is and what it means, and how we feel about it. What's your take?
I am really concerned about all the talk about this going federal and first of all, just because the feds might be able to bring charges in this case doesn't mean they should. It's a high profile murder, and merely because one is murdered, and the feds might be able to get jurisdiction over the case, doesn't mean that the feds should always take it.
Yeah,
Leave to the, and this is what I always thought was kind of the one of the core arguments on, if you will, the right. which was we want small government. We want states to make their own decision to do everything, to handle everything, and
Yeah.
let's downsize the federal government. And this is one way to do it: is keep the feds out of all the crime. The states can prosecute, and Utah has the death penalty. If anybody wants
Yeah.
him to see the death penalty, Utah can do it. So I just like to start there. First of all, even if this was if the feds could get jurisdiction, I don't think this would warrant federal jurisdiction, mainly because it seems just to smack of politics.
Oh, you
Because
think?
just to focus on this guy, exactly, like I'm not going to say anything that
Well,
isn't
dude,
that because
but it's
half
just,
staff, the flags and all that stuff. They're making it too. The federal government is just kind of cherry picking that this guy is worth more than other victims of crimes that could go federal, but they leave to the states. So that's one problematic area from a policy perspective. From a legal perspective, I don't see there's any way for the feds to get jurisdiction over this case. So
why not?
immediately,
Use of a
okay, so
firearm in a crime of violence.
well, so you have to
924C.
travel. You have to go across state lines. That's how they got
Mm,
Mangione. So
yeah.
Mangione got
Mm,
interstate. He was charged with stalking, and that's how they got
hmm.
the going over the state lines, use of interstate facilities. I'm just going through his indictment right now. They did charge him with murder through use of a firearm, so I guess they could get that. That's 924J. That would probably be the only count, I think, that might stick. Although, I mean, I don't. Apparently, this firearm that was used by Robinson was from his grandfather. It was a gift from his grandfather, and it's a very rare bolt action rifle. So I'm not sure if it was made in interstate commerce, made outside of Utah, and then the parts or the firearm was transferred into Utah. So there's an open question about that, but that would be the only statute I think that they may be able to get jurisdiction federally is that 924J, which again smacks of politics to charge. Because it would seem then in every single case there was a murder, and this goes back to my other point about the over federalization of crime, is then that every single murder involving a firearm could go federal. And what are the policy decisions? Why does the feds choose some cases to take some firearm murders to go federal and others not? It just seems
Yeah.
to smack of a politics without there being uh, some very clear definition of policy reasons why we would take this and why we would reject other cases to charge them federally. But that would be it. It would be just through the murder through the use of a firearm under 924J.
Yeah.
That
Yeah.
would be the only way they
Well,
can get it.
but it does make me think of all these Tesla cases because
Yeah,
even though it's easier to, I guess there's more of a grounds, more of a basis to charge federally. What you said, just because they can doesn't mean they should. And the way they're getting jurisdiction under these arson cases where people are burning Teslas is the Interstate Commerce Clause. And it talk about stretching something so
yeah,
far until it should just break in two. This is the theory is if the arson involves something that traveled in interstate commerce, then it's
yeah,
federal. And that's everything everywhere all at once, unless he went
yeah,
straight to the Tesla factory. But even then, I guarantee you the parts, that they used to build that car probably came from another state or another country. Like there's never, it's very, very difficult for me to imagine a scenario where something hasn't traveled in interstate commerce.
right,
And so the question then becomes why not federal? Arizona's got arson charges and every state has arson. Every
yeah,
state's perfectly capable. Like Utah
yeah,
is perfectly capable of trying this guy,
right.
assuming he's, guilty and they have the death penalty. I
Hmm.
could understand if it happened in a state with no death penalty and the government, the feds were gung ho about death, but that's not the situation here.
Some may be arguing, well, wait, how can the feds and the state take the case at the same time. Doesn't that violate double jeopardy?
Oh, well,
And the answer is
Mangione
no.
raised that
Yeah.
in his brief, but
Well, that's because New York kind of has an interesting statute that applies that makes it worthwhile to raise that. But generally, at least under federal law, there is no double jeopardy because of what's called the dual sovereign doctrine. So double jeopardy only applies to a single sovereign, the feds trying you again for the same conduct, or a state trying you again for the same conduct. But if you have two separate sovereigns, the state and the fed, they both can try you for the same conduct without violating that. And most people don't under or are not aware of that. So just worth pointing that out here.
yes, I
Yeah,
love that. Now, here's a couple of things I'm interested in
yeah.
on this federal thing. First of all,
Mhm.
why is there not a conflict of interest? Because in my jurisdiction, say something happens in Maricopa County, and
Yeah,
the lawyer in the case or the prosecutor, the county attorney has some direct personal connection to the case.
yeah.
Basically, they have to conflict the whole office out, and they send it to a neighboring county, Yavapai County or something like this.
Hmm.
Well, in these Tesla cases, the whole reason they're prosecuting them federally is because Elon Musk is directly connected personally, professionally, politically to the White House, to the DOJ. Um,
Yeah.
and the same with this is the quintessential example. I mean, fucking JD Vance is a pallbearer at this poor guy's funeral.
Well,
So
yeah, and
where does their DOJ get off
right.
not have a conflict of interest in prosecuting?
Well, right. It's not just JD Vance though. It was Cash Patel too
Oh
at the
yeah.
news conference when he announced the capture of Robinson, and he stated to Charlie Kirk, he kind of teared up a little bit or got a little emotional and
Yeah.
said, "I'll see you in Valhalla, brother." Uh, which just to be,
And guess
that's
what?
just
Here's another problem. Talk about taint in the media and pretrial
Oh
publicity.
yeah. Oh, absolutely.
And
Absolutely.
this is a
But
little
here's
known fact. Do you know that there is a Department of Justice policy? Apparently, they don't know, these fucking people in the Department of Justice, um, but that it's 1-7.500, release of information on a criminal matter.
yeah.
Um, Their policy says a news release issued before a finding of guilt should state that the charge is merely an accusation and the defendant is presumed innocent until proven guilty. Have you heard one little iota of a
No.
murmur of
No.
about,
No.
oh, just so you know, it's he's presumed innocent?
Yeah.
No, this guy is tried, convicted, and almost already
Well,
sentenced.
it was what the governor of Utah said at the very beginning of the press release or the press conference. He was like, his first three words were,
We
"We
got
got
him.
him."
We got
Yeah.
him.
So, and even Trump said that earlier in the day on Fox News. So, but when going to the conflict of interest, there's something else that I don't think Pam Bondi, Kash Patel, and certainly Donald Trump, or many of the folks that remain at the DOJ are aware of, and that's 28 USC 528. And that pertains to disqualifications of officers, employees of the Department of Justice. And it reads thus: the Attorney General shall promulgate rules and regulations which require the disqualification of any officer or employee of the Department of Justice, including a United States attorney or a member of such attorney's staff, from participation in a particular investigation or prosecution if such participation may result in a personal, financial, or political conflict of interest or the appearance thereof.
It's all of the above. Check every
It's all of
fucking
the,
box.
yes, exactly.
And
Exactly.
now, may I do a moment in history to tell you how far we've fallen in this country from the way the protocols and the norms and our respect for due process used to be? I'd like to take you back to um, August 4th, August 3rd, 1970. A great year. One of the best years in history because it was the year of my birth. This is an
Mine too.
article. This is an article from the New York Times, and I wish I could blow it up and show it to you, but this is what it says. President Nixon asserted today that Charles Manson, a hippie cultist now on trial in California, quote, was guilty, directly or indirectly, of 8 murders without reason, end quote. But faced with criticism that he had prejudged the outcome of the Manson trial,
Yeah.
Mr. Nixon issued a statement on his arrival here tonight saying, quote, "The last thing I would do is prejudice the legal rights of any person in any circumstances." So he withdrew his. The headline is Nixon calls Manson guilty, later withdraws remark. So I'll be waiting for Trump and Cash Patel and JD Vance and
Yeah.
fucking who's that jerk off Stephen Miller. I'll be waiting
Right.
for all of them to withdraw their comments and say, we really need to calm down here, let the process take its course. Everyone's innocent until proven guilty, and God forbid we, make anyone angry or turn up the rhetoric. So
Yeah.
so there's that,
So yeah.
which is crazy. Um, and there's a lot of crazy things to say, and I guess we don't need to comment on our personal views and opinions, except to say that I will say unequivocally, I would never, ever, ever celebrate the death of another human being, period. Um, our country will not be better off for him being gone. Not because I believed he was a great voice and a great light, and I believed in his work, but because I believe that this is going to lead to horrible, violence begets violence, and the administration's doing nothing to tamp that down, and things are going to get bad. Things are going to go
Well,
bad. Well, let's talk about terrorism. I will tell you this. Well, I think I've said it, but I'm just terrified to see what comes next and how the administration is going to use this to really go after political political opponents. That's all this is.
okay. But that's now. I think this
And
is
by branding them as terrorists. So let's go.
exactly.
Yeah,
Boom,
exactly.
boom, 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 boom. Yeah.
Right.
So so first of all, what is terrorism? Here's the federal
Good
definition.
question. Okay.
Yeah. Yeah. Um, the federal definition is, and this is 18 USC 2332B. By the way, when I was with the U.S. Sentencing Commission, I was on the terrorism team right after 9/11. So I'm very intimately familiar with this
Mm-hmm.
and the terrorism enhancement. But
Yep.
18 USC 2332B actually defines a federal crime of terrorism. And before I give you the definition, I'm going to say it's kind of an oxymoron because there really is no actual federal crime of terrorism. You can't be charged with what I'm going to be reading you. It's for another
Mm-hmm.
purpose. But at any rate, so federal crime of terrorism means an offense that is calculated to influence or affect the conduct of government by intimidation or coercion or to retaliate against government conduct. So it's focused on government conduct, okay?
Mm-hmm.
And it has to be a violation of about one of 3 dozen statutes. And it's very specific. So federal crime of terrorism can't be just anything. It has to have basically that intent behind it to calculate or influence the conduct of government, focused on doing something to affect the conduct of government, and a very specified statute, such as the very first one listed here is destruction of an aircraft or aircraft facility, violence at international airports, arson within the special maritime jurisdiction of the United States. It could be just, as you and I know, just arson generally. What's interesting, though, that's not listed in here is murder. Murder with the intent to affect the conduct of government isn't listed in here. Although what is listed that's similar to it is anything relating to killing or attempted killing of officers and employees of the United States. So if you go after a federal official, for the purpose of intimidating or affecting government, the operation of government, that could constitute a federal crime of terrorism.
Hmm.
So at the end of the day, really what it boils down to, it's a very well, part of it's well defined. It only could be a certain type of offense. It has to be an enumerated offense that is committed with a rather ambiguous intent. And by ambiguous, what I mean, calculated to influence or affect the conduct of government. What does that mean?
Hmm.
Well, that in and of itself is not defined. So, but how would you prove that up? How would you prove that you committed an arson or you murdered a government official? Let's say you were one of the January 6th, probably the best example would be
Yeah, I was just
one of,
thinking about that.
yeah, one of the
That
January
seems
6th
to be a
guys.
textbook definition of
Eh,
interfering with the function, the
exactly.
conduct of government.
Right.
Yeah.
And so you could not get a better example of that. And as a matter of fact, every single plea agreement, I mean, there was almost I think over 1,000 now, were charged before the mass pardons,
Mm,
before
right.
Trump came back in office. But there was just over 1,000 individuals that have been charged
Yeah.
with assaulting the Capitol building on January 6th. And every single plea agreement, just about all of them pled guilty, like usual, had in there an agreement that the government could argue for an upward departure for terrorism. And the reason why it was an upward departure as opposed to an actual adjustment, getting a little technical here, is because of all the underlying offenses were not one of these articulated, enumerated statutes. In other words, there was no, when you look at this list of statutes that are at 2332B, when you look at them, none of them are trespassing into the Capitol building or
Hmm.
vandalizing the Capitol building or trying to obstruct the administration of Congress. And that's what a lot of these individuals, the January 6ers, were charged with. Those statutes or variations of those statutes. None of them are enumerated federal crimes of terrorism. But nonetheless, under the sentencing guidelines, you could take any offense and still depart upward if your intent may not have been directed at the government, but at a civilian population. And so that also is okay, Mark. Now
Well,
we're
so
talking
first of all,
government
well,
population.
yeah,
Yeah.
yeah, yeah, yeah. So, and since we are primarily operating in the federal world, and the federal guidelines are the ones that are really the tail that wags the dog when it comes to
Yeah.
these terrorism cases, people need to understand there's two parts to the terrorism enhancement. One is what you just talked about, affecting government, which
Yeah.
is what is that? 3B1 what?
It's
3B1.
so there's something called an upward adjustment.
Yeah.
And the upward adjustment applies if it's an enumerated offense and it was calculated to influence or affect the conduct of government.
Yeah. And it's a big, big, big adjustment.
It's
It's
a
a
plus
it's a
12 with
12 levels, which is probably the biggest. I
it
mean,
is the biggest.
it's
It is because there's also a
yeah,
floor of 32. So
yeah,
let's say you're starting out like at an 8. 8 plus
yeah,
12 is only 20. Nope,
yeah.
you're going to go
So
all the way up to floor.
you're
It
going to
has to go
32.
up to 32 at
And they
least.
bury the needle in the red on criminal
Yes.
history. You go up to there's 6 categories.
Yeah.
You get automatically bumped to categories, even if you have no criminal history, you've never
Even if
been
you
in
have
trouble in
none.
the world.
Yeah.
So you're basically like literally the needle's buried in red.
Yep. Go
Not
all the
not
way to
not
6.
literally, actually. That
Yeah.
that would be an improper use of the word literally. Figuratively, because there is no needle in the
Mhm.
sentencing guidelines, although sometimes it feels like you're getting stuck with something. But anyway, okay, so that's on the in the guidelines proper, and then there is something related to that called Note 4, which we are all
Right.
too familiar with, because
Yeah.
that deals with a civilian population. So we're talking about, okay, we can't prove that you did this to influence conduct of government, but
Yeah.
if you, what does Note 4 tell us?
Okay.
Well,
What not
there's
but go
dead.
ahead.
No,
Yeah.
Note 4 is kind of dead, but it's still relevant. But anyway,
Well,
what's
I'll
the
explain why
civilian
it's dead.
aspect?
Yeah.
Yeah.
So we have two things. You have an upward adjustment, which is actually the calculation of the guideline.
Yes.
And then you have something what's called an
Uh,
upward departure.
Departure, yeah.
And that's okay. You've already calculated your guidelines, and it says your the sentencing range is 50 to 71 months, something like that. And an upward departure, it allows a court to sentence above that 71 months, above the top of the range, um, as opposed to calculating the actual range. The adjustment calculates the actual range, and the upward departure, is a reason to go above that range. When I say it, it sounds like, well, what's the difference? There's a difference in sentencing law that's not really worth going into, but at the
Yeah.
end of the day, it really doesn't matter. But
Well,
um,
it does highlight how stupid, like how
it,
convoluted,
it
unnecessarily
is, it
convoluted,
is,
because
it is.
you have upward adjustments, you have upward
Yeah,
departures, and you
right.
have upward variances, which
Exactly.
we'll get there.
Yeah.
But so what is this one? This one is
So the
note four
upward
was an upward departure,
Yeah,
right?
it's basically to try. It's a workaround that the commission put in, which I
Hmm.
think they did illegally. But I don't think it's worth talking about it. But I think they did it illegally. Um, it's a workaround where the offense of conviction is not one of these enumerated cases, or it is one of these enumerated cases, but the intent wasn't to affect the government, but rather more generally a civilian population. So, in other words, I committed arson to scare everybody in the Phoenix metropolitan area, to intimidate them. Then that would, assuming the Phoenix metropolitan area, everybody that lives there would be considered a civilian population. That would, as a judge, I couldn't give you the upward adjustment for it, but I could depart upward,
Yeah.
and to the same degree as the adjustment if I wanted to. So
Uh-huh.
that's really, it's basically a workaround. So
Yeah.
if 3A 1.4 doesn't fit what the commission said, screw that. If it doesn't fit directly here, you can go this way.
Yeah.
We'll give you another
Right.
way to do it.
Right.
So that
And
that's really
so,
what the departure is for.
and spoiler alert, but that the commission recently did away with upward departures, right? So that note
Across
four
the
is,
board. So starting
yeah,
November 1 of this year,
yeah,
all departures except for departures for cooperation or substantial assistance
yeah.
go away. All of them have been
Right.
now, and we have a podcast on
And
on
but
that
the
one as well.
commission gods take away with one hand and giveth with the other, because what they're saying is, even though this is not a formal upward departure anymore because note four is going away,
Yeah,
ultimately we always have 3553, where the court has to look to the nature and circumstances of the offense, among other things. And so presumably, well, not presumably, the commission basically says as much, right? That the
yeah.
judge can still consider this civilian population element to give an upward variance in sentencing.
Well, actually, that all that language goes away now. So there's not there. It all the commission now says is for any sentencing,
Yeah.
any, regardless
Yeah.
of whether it involves terrorism or not. You can always vary upward or vary downward. It's just
Yeah.
up to you. And basically, the way I read it is, you know what? The guidelines really don't matter anymore because
Yeah.
nobody's following them, and we give up.
Yeah, they're falling
So
to pieces,
they're
like
falling to
piece by
pieces.
piece,
So yeah,
which
exactly.
we've seen this unfolding over the course of
Yeah,
years, and we've
yeah,
really kind of cheered that on, because
yeah,
we call these the drunk uncle, that they're advisory, but they give really shitty advice about what the sentence would be. But
right.
what you're
Yeah,
saying is, okay, I mean, in the worst case scenario, what I'm saying is,
yes,
even though note four goes away and it doesn't specifically say, coerce, intimidate a civilian population, we know what's going to happen. The government's going to
okay,
come in at sentencing
yeah,
in, whatever case, and say, I understand that they did away with the upward departures across the board, but this is still an element of, this is still a terrorism case. And the
yeah,
reason is because it was designed to intimidate or coerce the civilian
right,
population, and therefore you should give a significant upward variance under 3553. So the
Right.
definition of terrorism still is relevant, even when it comes to coercing a civilian population.
Right.
And this is why we're talking about this today, because this
Yeah.
case in Mangione, first of all,
Yes.
it's a state case, so
Yeah.
it's not directly applicable, but they used the federal statute to do the New York state. The language is almost
Yeah,
identical.
it's almost identical. Yes. So shortly after 9/11, New York State, because of the Twin Towers, they passed their own version of the federal crime of terrorism statute. And they basically looked at 2332B. And unlike the feds, like what I was saying before, so this definition of a federal crime of terrorism in under the US code actually does not define a specific crime. In other
Yeah,
words, you cannot be charged with a literal federal crime of terrorism.
right.
18 USC 2332 BG5
Yeah,
is not an offense. It's
yeah,
just a definition.
right.
And that definition, in turn, is used for various purposes, one of which is to define who qualifies for the adjustment, the
Hmm.
terrorism adjustment under the guidelines. So New York looked at this definition
Yeah,
of a federal crime of terrorism and created its own definition of state terrorism that constituted an actual offense.
yeah,
And that's what Mangione
yeah,
was charged, or one of the
yeah.
offenses he was charged with was
Two of them.
terrorism.
One was
Yep.
murder in the first degree with a
Yeah.
victim killed in furtherance of an act of
Right.
terrorism, as
Yes.
defined in PL 49005, and the other is murder in the second degree as a
Right.
crime of terrorism. So it's
Right.
built right in there, and it's an element of the offense that must be proven first at the grand jury and then eventually at trial. So this whole argument that they're making his lawyers clearly able defense lawyers in Mangione, is that
Yeah.
there's insufficient evidence to support terrorism here. So the court's looking at that in this case, and they, spoiler alert, they said that's right. And again, they did two prongs. One is, does this affect conduct of government? They just
Yeah.
dismissed that out of hand
Yeah.
because he killed a CEO of an insurance company. And they said
Mhm.
that that's such a tenuous connection to government policy, law, whatever. We're not even giving that any real consideration. So they really dug in deep, deep, deep,
Mhm.
deep on
Yeah.
this issue of whether his alleged conduct of killing a
Right.
CEO of a healthcare was meant to intimidate or coerce a civilian population.
Right.
And so, what the fuck is a civilian population? What does that even mean? And how did the court come grapple with that?
Well, the first thing the court said it did is it focused on or discussed just the term of terrorism itself. It said the
Hmm.
court says the court will note that the term terrorism has been famously difficult to define. Our Court of Appeals has cautioned against expanding the definition of terrorism beyond what the legislature intended. The concept of terrorism has a unique meaning, and its implications risk being trivialized if the terminology is applied loosely in situations that do not match our collective understanding of what constitutes a terrorist act. The legislator incorporated a general definition of the crime and referenced seven notorious acts of terrorism that serve as guideposts for determining whether a future incident qualifies for this nefarious designation. And
Yeah,
those guideposts, those seven
yeah.
notorious acts, well, one of which,
There's some big ones. In
yeah,
fact,
yeah,
the biggest one of all,
9/11, yes,
9/11.
nine
And
eleven,
the other one, big, 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 Oklahoma City.
yes,
These are two of the ones that were underlying all the federal legislation, right?
right,
Yeah, so I thought that was really interesting because when they're making this statute, they're saying, look, these are
yeah,
examples of
right,
real terrorism. And
right,
they cited to those in the legislative findings, so we get a really good glimpse into what is their rationale for creating these events. So terrorism, we said 9/11, Oklahoma City, bombing
Ted
of
Kaczynski, Ted
the
Kaczynski,
was he on that list? Unabomber? he talked about
Yeah.
Ted Kaczynski. I don't know if he's on. I'm looking at this list. It was one
Oh,
was 9/11, two was the
okay.
bombings of the American embassies in Kenya and Tanzania in
Mm,
1998, three Oklahoma City,
mm.
four mid-air bombing of Pan Am Flight 103 in Lockerbie,
Yeah.
Scotland,
Yeah.
five, and this is interesting. We'll get to this
Yeah.
later, but there's the next two seemingly seem like smaller scale.
Yeah.
Five was the 1997 shooting from atop the Empire State Building. I don't even remember that one. Nor do I remember number
Mm.
six, which is the 1994 murder of Ari Halberstram on the Brooklyn Bridge. Oh, and then number seven was the first World Trade Center bombing in 1993.
Yeah.
Yeah.
Well,
So
see, you
there's
know what a lot of these have in common that two of them I don't know the five and six I wasn't familiar with those examples,
I
but
wasn't either.
but what the others have in common, and this might be for a different conversation or some article you and I need to write, is terrorism also should be defined by who the offender is. These offenders, all five of them at least, were state sponsored
Yeah,
offenders. Those guys that took down the World Trade Center, the two
absolutely.
towers, they were state sponsored. The bombings of our embassies in Africa, state sponsored. Lockerbie, that was
Yeah,
Gaddafi. So
right.
I think it's not enough to have a political motive. I think it's also who you are in terms of well, who you are. I mean, are you just some lone wolf? Are you acting on your own? Or, as you and I were talking about offline before we started the podcast, are you conspiring with a well organized or recognized group, such as a state,
Yeah, like Al
like
Qaeda.
Libya or
Well,
Al Qaeda
Al
or,
Qaeda. Well,
Iran?
and just I may be jumping ahead, but as long as we're on the subject of those other two, the government was basically trying to say, I mean, I think part of Mangione's argument is how is this a civilian population? It's one guy,
Yeah,
that was killed, and that's you can't have a civilian population out of one guy. And they
right.
pointed to those other two and said those were single victim
Yeah,
cases.
right.
But the court says, slow your roll here. And it goes back to what you're
Yeah,
saying as to who is the person and their motivation, because they
right.
say um, they don't have to reach that issue, but they will note, the court says that, slow your roll. The Empire
Yeah,
State shooting and the other killing on the Brooklyn Bridge, that's a misplaced analogy because
yeah,
those incidents were very different from the one presented here. He said in the 1997 shooting in the Empire State Building,
yeah.
the government expressed his desire for revenge for the treatment of Palestinians and opened
Mm.
fire with a semi-automatic weapon on the observation deck, killing one and wounding six others. So it wasn't a mass shooting, but by virtue of luck, because he certainly tried.
Well,
And,
it was
and
a mass shooting, not a mass murder.
mass murder, and
Yeah,
and also his ideology was one of religious, or one of
right.
treatment about it was political, it was
Yeah,
treatment of
political.
Palestinians.
Yeah.
And then the other one is the gunman's motivated by a desire to retaliate against Jews, fired, quote, shot after shot into a van of Orthodox Jewish students, killing one and injuring three others.
Yeah.
So,
Well, see, that
this,
would I would classify that as a hate crime, and that's another podcast that we need to do is the distinction
yeah,
between terrorism and hate crimes because those
right.
get conflated quite a bit.
Oh, absolutely. And by the
Yeah,
way, there's a federal enhancement for a
for
hate
hate crime,
crime, and it's like
three
two,
levels.
three levels.
It's three levels, and you have to prove it beyond a reasonable doubt. But terrorism is 12 plus
Yeah,
criminal history six, and that's just preponderance of the evidence.
yeah.
Whatever.
This is pretty screwy. Can I digress for a second?
Yep.
And I
Yep.
feel like
Yep.
it's definitely a digression, but it's an important one.
Okay.
And because I will tell you, put the terrorism stuff aside, this is every case we're talking about in New York and Arizona and many other places, but not in fucking federal court, excuse my French.
Yeah.
But how does this opinion start out? It starts out talking about the grand jury proceedings. They're
Mm.
making a motion that there's insufficient evidence to legally support this element of terrorism. So it's a factual inquiry to see if the facts presented at the grand jury meet the definition, the elements of terrorism as defined under New York law. And they filed a motion to inspect the grand jury minutes for legal sufficiency
Mm,
pursuant to the statute on the books that allows them to do that. And
mm,
I want to highlight that because
yeah,
um, you can't do that in federal court.
yeah.
You basically need an act of God to get at the grand jury transcript.
Mhm.
So, barring very limited, rare instances, you'll never see what evidence was submitted there to even bring the charge.
Yeah.
And as you know, just bringing the charge is an earthquake. I mean, it's an epic seismic shift in a defendant's life when there's a grand jury indictment, even if it doesn't make it to fruition of guilt or
Yeah.
conviction. And
And it's almost
this
impossible to get it dismissed, at least pre-trial.
Right. And I will say this is one of my has always I've been in federal law in federal court for decades now, and this is my biggest beef of all because what I was used to, I came from state practice in Arizona, and they had looked like one better than New York. When I got a case in the state of Arizona, I could automatically request the grand jury transcript, no questions asked. And I will
Wow.
get it every time because I'm entitled to it. And then I get to review that and see everything that was presented. And not only do I get to see everything that was presented, I get to see anything that wasn't presented that should have been presented. In other words, the defendant in Arizona has a right to have exculpatory evidence
Oh,
presented at the grand jury. And if you look through that and say, well, there were two other witnesses that said they couldn't, identified someone else as the shooter or whatever, and they didn't because they never do. They just present the smallest
mm,
amount of evidence to get the indictment, right?
mm,
You can file a motion to remand and say, this was wrong, that was wrong. They should have presented this, that, and the other. And good lawyers in Arizona do that in every single case. And a lot of times, not a lot, but not a few. I've had cases remanded to the grand jury, and we do what's called a Harold Trebus letter. That's it's named based on the case law that gave us that right. And so you get a remand, then you write a letter to the prosecutor and you say, great, I know you're going back to the grand jury. Just make sure that you present this, and this,
So,
because
so the prosecutor has to show what we would call Brady at the federal level too.
yes,
Yeah.
yeah.
Wow.
And
Wow.
and
Yeah.
sometimes you've done such a good job of showing them the weaknesses in their case, they just give up. They don't they don't go for another indictment. And then sometimes they go for another indictment and they screw it up again. And you get the transcript again, you go through the whole dance. And that is exactly, in my humble opinion, how it should be in every court in all the land, because that's a secret proceeding. And there's
Mm,
no place where it's more secret than in
yeah.
federal court. People
Rule
don't
6. Mm,
necessarily understand that, but that is, in my mind, one of the great injustices of federal criminal law. So put that in. And
yeah.
now that doesn't, and I still think that lawyers should be making those motions in federal court. I don't think they're frivolous. If you can point to other states and other case law to say, I know what the law is here, but it's wrong, and here's why, and ask for those transcripts, you will get denied. And you might preserve an issue for appeal, but I feel like the more people make the argument that someday, somehow, some way, we could get the change, some change.
Yeah.
But that's my little practice pointer and my little soapbox, and I'll step off it. Let's get back to terrorism.
Well, so, what does this mean then? The Mangione decision today, and let's assume, and it was very well, I think it was very well written, the
Yeah,
opinion, and
it
well
will be
sourced.
appealed.
Yeah, of course it'll be appealed, but let's assume that it's going to be affirmed. And what impact might this have on other cases? Well, even though it is normally state cases, state criminal decisions are completely irrelevant to
Yeah,
federal criminal law. But here, this is one of the rare times where I think it's very relevant because the New York State statute is modeled after the federal criminal statute that defines federal crime of terrorism.
Yeah.
And so there can be some relevance there in terms of how this judge decided what constitutes, what evidence, what words that the defendant said or wrote
Hmm.
constitute or are sufficient to show that he had the requisite intent either to target his conduct at the government or at a civilian population, and more to the point, how ambiguous or really vague, and there's a difference between ambiguity and vague, by the way, just, and people often conflate the two. Something is ambiguous. If something is ambiguous, it means it can it, two or at least two, maybe three or more definitions can be held for that particular term. It's not
Yeah.
that we don't know what that term means, but it
Right.
can mean certain things in other contexts,
Hmm.
as opposed to something that's vague. If it's vague, it doesn't really have a well-defined meaning in any context.
Right.
And that really is terrorism
Yeah.
and civilian population.
Yeah.
Government is not a vague term. I think we all understand what is meant by government, whether it's local, state, or federal. But when we talk about civilian populations, what does that mean? And
Hmm.
does it have to be like the whole country? Can it be
Yeah.
smaller than a country, or
Yeah.
can it be like just employees of a large organization or a medium-sized organization? Is it the people on your block or in your apartment building? Could it be people at your Christmas party? Is that enough? So
Yeah.
it's just too vague. And the same thing with the concept of terrorism, which is why I think the state of New York, when it drafted its definition of terrorism, had to resort to actual examples because it is so hard to define the political
Yeah.
nature of that. It's inherently vague, is the problem
Yeah.
with trying to define a federal or state crime of
Yeah.
terrorism. There's just so many vagaries in that. And so, why this is relevant, back to what I was saying to begin with, why is this relevant to the state cases? Because, as an example, let's say that Charlie Kirk's assassin, they do try to bring a federal case. They absolutely are going to try to give him the federal crime of terrorism upward adjustment at 3A 1.4. And so here he may be able to cite to this case and say, look,
Yeah. This has nothing to do
yeah,
with
I shot
government.
Charlie, but this had
Yeah.
nothing to do with government
Yeah.
or a civilian population. I
Yeah.
just hated what this guy was saying, and I
Yeah.
wanted him to shut up.
Yeah.
That's why I killed him.
Yeah.
But just because it may have affected a lot of people and a lot of people saw it because it was being
Yeah.
live streamed and all that stuff, and maybe that was foreseeable to me, and it certainly was foreseeable to me that the 3,000 people around there would witness all of that. I didn't really give a shit about all of that stuff. I just didn't like what he said. And so
Hmm.
this is something he may be able to, his attorneys may be able to point to
Yeah.
Mangione, and Mangione didn't do his assassination in front of a bunch of crowd,
Right.
or a big crowd or anything like that. He did it like in the morning, as I recall. He just
Yeah.
ran it behind the guy and shot him from behind. But still, that was captured on TV or closed circuit TV, and it was widely
Yeah.
disseminated, and everybody
Right.
got to see that. Yeah,
Everything you have to assume in this day and age that anything you do could be widely disseminated. And again, there's not going to be any proof that that influenced his look, if he would have, God forbid, went to his house in the middle of the night and done this, he'd still be accused of terrorism in the exact same way. They're just looking at what is the evidence in Mangione, and Mangione, it was very clear what his
yeah,
motivation was. He stated it, and there was no other evidence to contradict that. He wished to spread a quote message and
right,
quote win public support about quote everything wrong with our health system. So
right.
he was trying to gain attention to make sure not to intimidate or coerce the public, but to
But to
educate the public.
educate,
Yeah,
yes, not
and make sure they
intimidate.
understood
Right.
that our system is broken. No,
Yeah,
and that was his motivation, and not
yeah.
to instill fear. And then they're saying, okay, well, no, well, he wanted to get, healthcare policy changed, so it was government conduct, and the court just blew that off like out of
Yeah.
hand. No, there's no government conduct. Now, I'm interested to know about that in the Tesla cases, but maybe we talk about that later. But to keep going with that, then the government says, okay, well, it was meant to intimidate or coerce a civilian population.
Mhm.
And what did the New York have to say about
Well, yeah,
civil-
what
first?
the
First,
judge,
they made him say, "What is the civilian
wait,
population?" And
wait.
I think they were trying to say it could be a population of one, this CEO, but otherwise it's the whole healthcare company or United Healthcare, that
That's
whole company, and they were really
yeah.
afraid after this. They, and or the whole healthcare, private healthcare company.
Well, I
And
mean, maybe like
court wasn't
the
buying
six or
any of
seven,
that.
yeah, the six or seven other CEOs that had to up their security
Yeah.
for a week or two. But what the court said is the people assert they have established all three intents, although they focus on intimidating or coercing a civilian population. Yet they also briefly argue that the defendant intended to influence or affect the policy of a unit of government by intimidation or coercion. There was insufficient evidence presented to the grand jury to support this claim. There was no evidence presented that the defendant made any demands of government or sought any particular governmental policy change, let
Mhm.
alone that he did so by intimidation or coercion. Okay. So, right there, I think that's going to be helpful to Robinson
Yeah.
and others, like in the Tesla case.
Yes.
And
I think so
then,
too.
indeed, as the federal authorities noted, the defendant's goal appeared to be to draw the public's attention to what he perceived to be problems in the healthcare industry. The people placed great emphasis on one, and this is important. I love this part. The people placed great emphasis on one snatched phrase: revolutionary anarchism, in
Mm.
defendants' writings to suggest that this satisfies the statutory element of an intent to influence the policy of a unit of government by intimidation or coercion. Not only does this stretch the import of a two-word phrase beyond what it can carry, but it ignores other more explicit excerpts from the defendant's writings in which he states that as you said already,
Yeah.
that his goal is to spread a message and win public support about everything wrong with our healthcare system. So now, what the court does do with respect to a civilian population is it discusses an older case out of New York called the Morales case, and
Yeah.
that involved a street gang that had taken over an apartment complex, and the government there charged these gang members. One of the gang members had fired a bunch of shots at rival gang members during a party that ended up paralyzing a 10-year-old girl and injuring others. And the prosecution, I'm just going to read from this, the prosecution argued there was sufficient evidence of terrorism because the defendant intended to intimidate or coerce other Mexican gangs and, by inference, all Mexican Americans in the geographical area. But as the court points out, the appellate court in that case, the Morales case, said no, that's a Mexican American population of an apartment complex or even in that area was not what the legislature
Hmm.
meant when it was trying to define a
Yeah.
civilian population.
Yeah.
And it found that the context in the statute by those examples weighed against stretching the meaning of the language to cover such narrowly defined subcategories of individuals. And almost finished here. Examining the legislative findings and the examples of terrorism listed, it was clear that the legislature intended to address extraordinary criminal acts perpetrated by the purpose of intimidating a broad range of individuals, not a narrowly defined group of particular individuals. And so
Hmm.
that's, I think, really where that's the one of the keys to
Hmm.
this vague phrase civilian
Yeah.
population.
Yeah.
It cannot be particularized when you're starting to go
Mm.
through hoops and machinations and saying, well, the civilian population in this case was all the people that had health care coverage under this organization and stuff. Then it's no, you're getting too particularized there.
Hmm.
It has to be basically, it has to be as broad as the term is
Yeah.
vague,
Yeah. Yeah.
essentially.
Yeah. Yeah. And so broad range of people is very significant, I think,
Yeah.
because
Yeah.
it's not one CEO, it's not even the whole United Healthcare. It's not even the whole health insurance industry
Yeah.
who were all freaking out after this and had to get extra security. It's got to be
Yeah.
more that that's why I read this.
Right.
It's got to be
Yeah.
even more than that. I mean, and the whole healthcare industry is a pretty fucking broad range of people.
Right.
And I read this as saying not even that.
Yeah.
So, you know, I just think this opinion, I hope this opinion stays because I just think it's
Well, what I really like
so
about this
of
opinion,
helpful.
yeah, I think it is very helpful. But really, who needs to read this are the New York State
Prosecutors?
Legislature,
No.
well, the New York State Legislature and Congress, and to get better definitions. I'm always reminded when we get into this morass of mess where judges do when they're trying to define a crime and what constitutes this and the sentencing
Yeah.
enhancement and the criminal element and all this stuff. This goes back to Otto von Bismarck. There's two things you never
Yeah.
want to see made: sausages and laws. And this is a great example of it, is just what a
Yeah.
mess it is trying to define
Yeah.
terrorism, and how it's because it is so vague and so ill defined that it leads to these, just facially stupid applications where, a guy who assassinates, the head of a healthcare facility is going to be, or insurance company is going to be treated the same as the nine
Yeah.
11 bombers. And,
Yeah.
and a guy that assassinates Charlie Kirk because he doesn't like what he's saying is going to be, treated the same as the bombers of our embassies.
Yeah.
No, no, that
Right.
they're completely different.
And
And that the feds even taking these cases too is another problem. But yeah,
right.
yeah.
Right. And the court stresses nobody's saying this was okay. This
Right.
is a heinous, horrible
Yeah.
act of violence, but we have a statute that covers heinous, horrible acts of violence. It's called murder.
Right.
And you don't have to then stretch this definition of terrorism because you think this person may have had an ideology. There's one other interesting quote that we talked about before we actually recorded, but I do think that it's worth pointing out, and it is, quote, there was no evidence presented of a desire to terrorize the public. So
Right.
again, this is defining what is that population, widespread, but terrorize the public, inspire widespread fear, engage in a broader campaign of violence,
Yeah.
or to conspire with organized
Yes.
terrorist groups.
Yeah.
So if
See,
there
I
was
think
some
that's key.
evidence that he was conspiring with, I don't know, what would be a terrorist group that targets healthcare people? I don't know. The Ku Klux Klan, because
Uh,
Grand Wizard was mad because he got denied his gender reassignment surgery by
yeah.
United Healthcare,
Yeah.
and I don't know. But the point is, we had, well, I don't know what the point is, but we had a case where a client, destroyed some property.
Yeah.
Essentially a vandalism case at his heart. He shot up some unmanned energy power stations in the middle of the night. Nobody got hurt. Few people lost power. There was damage that had to be repaired, significant
Yeah.
damage.
Yeah.
And they branded him a domestic terrorist because A, his
Yeah.
ideology, which was he was passionate about climate change,
Yeah.
and B, well, and he said exactly the same thing, the Mangione.
Mangione. Yeah.
I
Yeah.
wasn't trying to intimidate or coerce. I was trying to show awareness about this existential threat to humanity. I wasn't trying to hurt anyone or scare anyone. I was trying to save people.
Education, not intimidation.
Yeah.
Yes. Yeah.
I'm trying to help humanity here.
Right.
Arguably not
And
a
he didn't kill anybody. He didn't harm.
he
He
didn't
did
harm a
something. He did it in
soul.
the middle of the night,
He
and
damaged
yeah,
property, and
he
a few
just damaged
people
property.
lost a
Yeah.
few. I don't even know if people lost power, some company or pipeline, whatever. The point
Yeah.
is, he was prosecuted for his ideology, but
Right.
this is what you're going to get in every one of these cases. The government's going to go and seize all your computers, all your cell phones, subpoena all your social media, and they're going to comb every hair of your existence to find some evidence that you did this with a terroristic intent. And in this case, there was a document from years before that was prepared by an organization called the Environmental Liberation Front, I think. And so whatever, there was some connection or affiliation, the government says, to these organizations. I don't think they actually proved that they were terrorist groups, but and I don't think this is a holding in the case. I think it maybe is dicta, but they use this word conspire in this New York case. That there's no evidence that he conspired with an organized terrorist group. Now, one of these groups didn't even exist at the time of this prosecution. That's how old this document was. And
Yeah.
the other one existed, but it was very much in dispute whether they were a terrorist group. But the most important part of this was whether he had some writings from them or whether he agreed with them or, whatever. There's zero evidence that he conspired with them
Right. Right.
to
And
do
that, and
that.
that goes, yeah, and I think that's, what one of the things that legislatures should take into consideration when they hopefully redraft the law on what constitutes terrorism is taking into account the defendant himself, who is is mainly males, affiliated with. And, I would think that that really should be an element if we do not want to dilute what we call terrorism and make it so anything could constitute terrorism, like it's a default. Everything's
Yeah.
terrorism unless it's
Yeah.
proven not, as
Yeah.
opposed to, having affirmative criteria. So at the risk of not diluting it, there should be a requirement that for an act to constitute terrorism, that there's going to have to be some kind of conspiracy. It
Yeah.
can't be just one guy
Yeah.
with some crazy ass ideology out there,
Yeah. Yeah.
whatever it happens to be. Otherwise, I get mad at my friend for saying that he's a Democrat or a Republican or something like that, and I kill him because of that.
Hmm.
Now I'm a terrorist,
Yeah. Well, and yeah,
because
right.
three people saw it and now they're the civilian population. Oh my
Yeah.
God.
Well, government could probably comb through our 118, 19, 20 episodes of Set for Sentencing and take cherry pick statements
Oh
we've
yeah,
made and create some picture about our ideology. But
right.
the court said the people place great emphasis on the defendant's ideological motive, but there's
Mm,
no indication um, in the statute that a murder committed for ideological reasons fits within the definition of terrorism without
mm,
establishing the necessary element of an intent to intimidate or coerce. So they conflate an ideological belief with the intent to intimidate or coerce. So those things are completely distinct from one another.
mm,
And if people say, well, he has an ideology, well, okay, so what? You can call him a
yeah,
revolutionary anarchist. He can call
right.
himself a revolutionary anarchist if all he wants. But without the proof of the intimidation or coercion of the civilian population, you ain't got terrorism. And so we spent a lot of time talking about this, but I think for good cause because it is so directly relevant to all of this. And this is, I talked about this in the first
Mm,
podcast, so I won't beat a dead horse, but I was on the
mm.
kick about Timothy Snyder and his lessons
All right, right.
about authoritarianism.
Mm,
And you know, this was one of them. Not lesson number 4. When listening to politicians, distinguish certain words. Look out
mm,
for the expansive use of terrorism and
mm,
extremism. Be alive to the fatal notions of exception and emergency. Be angry about the treacherous use of patriotic vocabulary, because I'm telling you that is exactly well, it's what's been happening. That's why we brought it up then, but it's happening exponentially,
yeah.
dangerously now in the wake of Charlie Kirk's shooting. And can I just do one more bit of history? And people are really going to hate this one because
Uh-oh.
it's a Hitler reference.
Uh,
But guess what? There's a little thing called the Reichstag fire.
mhm,
And now, before people get their panties in a bunch, the Reichstag fires, I think, largely attributed as a setup by Hitler to
mhm,
to do this. I'm not
The false
saying
flag, as
the
it
false flag.
says.
I'm not saying any of that about Charlie Kirk, but the truth is this is 1933. So first of all,
Mm,
put that in your pipe and smoke it. This is 1933. It's at the very front end of all the shit that's about to come from Hitler and Germany. So
hmm
people always go, you can't compare Trump to Hitler. Trump's not Hitler. And I'm like, well, actually, I can, especially if I'm comparing to 1933 Hitler. He may not be 1941 Hitler, which is when the final solution is ordered
hmm
and the
hmm
mass extermination of all the Jews really kicks into high gear. Okay, he's not 1941 Hitler, but what was the Reichstag fire? Okay, that's the German parliament building. It
Yeah.
burns to the ground shortly after he takes power. There's an election coming up. And the fire's blamed on communist agitators, in other words, his political opponents,
Right.
because the Communist Party was getting power, they were getting popular, and they were going to challenge him in the upcoming election. So what happened? The fire happens. He uses this as a pretext to suspend civil liberties, to
Yeah.
suspend habeas corpus, to suspend rights that are akin to our First Amendment.
Oh, you mean like sending the National Guard into a bunch of cities,
Uh-huh.
except Utah? But
Uh-huh.
anyway.
And Stephen Miller is on TV threatening prosecutions against leftist liberal
Yeah.
Democrats,
Yeah.
saying we're the party of murder.
Yeah.
We're inciting violence, all this rhetoric, and me calling a Trump. So I'm probably going to prison now because I've compared this administration to the Nazis, and that, according to them, is inciting violence. Words matter, I guess.
They do.
And
Yeah.
so they use this to not just go after silence their political rivals, but to do mass arrests. They arrested every delegate of the Communist Party and threw them in
Yeah.
jail. Okay,
Yeah.
so what did it do? Crippled their participation in government. They couldn't participate in the next election. Hitler solidifies his power. Flash forward 10 more years, and then he's putting the Jews in ovens. But where does he start? He starts with his political opponents.
hmm
And that is exactly what this administration will use this tragic, terrible, unfortunate murder, assassination of Charlie Kirk to do. You watch. I
Yeah.
guarantee it.
Yeah.
So,
Yeah.
and the way they're going to do it is they're labeling us domestic terrorists.
Right.
That's how it starts.
So I hope Robinson's, for the good. It's going to sound awful, but for the good of democracy, I hope that Tyler Robinson's defense attorneys watch this podcast and get a copy of the judge, or the justices, as they call them in New York, opinion in the Mangione case, because this is not what happened to Charlie Kirk was awful, terrible. It was murder. It
Yeah.
was not domestic terrorism.
Yeah.
And that's what, to go on what you were saying,
Yeah.
I think that's what the Trump administration is trying to paint this to be, some type of domestic terrorism event
hmm
to go after all of his political foes. It's the Reichstag fire, to use the analogy.
Yeah,
Yeah.
it
Or
is. And
potentially.
I
But luckily
am
it's just burning
quite,
really small.
for
I
now.
for now, well,
For now. But we'll have to see.
yeah, yeah.
Until then,
Yep.
I'm sure we'll be doing this soon. But thanks for calling, Mark. I get these emails or texts from Mark in the morning. We have to do this podcast. We have to do it now. And you were right. We really do. This is timely and it's important, and
Yeah,
people need to
yeah.
know. And it's not
It,
like this is a one-off. It's not like
no.
there's not terrorism prosecutions happening all over the country. You know what the other big takeaway of this whole discussion is? Trump's in the Epstein files.
That's, well, we've all known that. There was no surprise
But I
there.
think I think we forgot after after the week's events. No one seems to be talking about that anymore. So, anyhow, well,
Give it
I'm
another
gonna
day.
rock and roll. Yeah, give it. Well, good question. Good. That'll be interesting to see. The more we go down this rabbit hole of the Reichstag route, the less we'll be hearing about Mr. Epstein and his shenanigans.
Yeah.
So, what a world, man. What a fucking world. I'll talk to you soon.
Okay.
All right, brother.
Take care, Doug. Okay. Bye.
That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.